to Pamela Price Unfiltered. I'm Pamela Price, your host. This is a space and the place for real talk. This podcast is all about raw, unfiltered conversations about law, politics, culture, education, systemic racism, and current events shaping our world. We'll go beyond the headlines to dive deep into how some of the most pressing issues are affecting real people, real families, and our community. My goal is to help you navigate the complexities of our world. Each episode will tackle an important issue and break it down in a way that's honest, informative, and actionable. We'll hear from community leaders, lawyers, activists, educators, healers, and everyday people on the front lines of change. For those tuning in for the first time, I'm Pamela Price, a longtime attorney, political activist, and champion for justice. Please subscribe to my YouTube channel to watch the show and my Substack to read the weekly word. Your support keeps the conversation raw and unfiltered. And you can listen to Pamela Price Unfiltered wherever you get your podcast. Okay, my guest today is attorney Cynthia Chandler. Cynthia Chandler boasts an impressive legal career of 30 years, during which she has co-founded multiple social justice organizations, including the Oakland Eviction Defense Center, Critical Resistance, Justice Now. In addition, she served as the director of the Alameda County Bar Association's Bay Area Legal Incubator, BALI, where she helped aspiring lawyers launch their practices and brought into service more senior lawyers to serve as mentors and guides. Her tireless efforts have played a vital role in California in advancing the rights of HIV-positive women in prison and putting an end to the forced sterilization of women in California prisons. Her groundbreaking work on that issue and courageous work is featured in the amazing documentary Belly of the Beast. Cynthia's unwavering commitment to the advancement of women's rights and access to social justice has earned her several prestigious awards, including the American Bar Association's Faye Stender Award. I had the good fortune of hiring Cynthia Chandler to serve as my policy director in the Alameda County District Attorney's Office, where she helped lead the effort to transform the criminal justice system on behalf of the residents of Alameda County. She walked in the door with me with courage and commitment in January of 2023. So often over the next 2 years, as we fought to push back against the status quo and make the system more fair and equitable, she and I earned a hated place in the minds of many of the deputy DAs who were really stuck in the past. Cynthia Chandler is an innovative thinker who is a master of technology as well as policy, and was the author of many initiatives to bring the district attorney's office into the 21st century, and our purveyor of legislation coming to us from Sacramento. So let's talk about it. Cynthia, welcome to Pamela Price Unfiltered.
Thanks so much for having me.
Of course.
Feels like coming home.
Thank you for joining us. There's been so much controversy and uninformed discussion about the enhancements since we took office. Before we took office, nobody knew anything about enhancements outside of Sacramento, as we'll talk about. But can you just break it down for my audience and explain what is an enhancement and why is it necessary in the criminal justice system?
Sure. So a conduct enhancement is when there's an extra potential penalty put on top of a base sentence for someone if they're facing criminal charges. So you can think of it as like you not only get the basic potential prison time for doing the conduct, but you also get an extra penalty for something that makes that crime seem especially heinous, or that it involves especially vulnerable people, for example. There's a thought that there are times where the penalty should be elevated beyond which someone would face for the basic conduct.
So one of the themes of criminal justice reform has been to make the time fit the crime. And how does an enhancement serve that purpose, if at all?
Well, I guess I would say it doesn't. Making the time fit the crime is not really, I think, the purpose of enhancements. It's sort of to say the base crime is not enough. In fact, the penalty is not enough that fits the crime. Instead, for some reason, and we can talk about the reasons, I think, we want to elevate and make that person's punishment stand out above all others. So it really is not that basic.
So talk about what in the special directive there was a process for approval of enhancements. And can you talk about how we developed the special directive and created the actual directive?
Sure. So to understand that special directive, I think we have to go back a little bit and understand the Racial Justice Act. So before you and me even came in the doors of the district attorney's office, there was a new, really important historic law that was passed in California called the Racial Justice Act. And that law was put in place to say in California, we were no longer going to accept racial sentences or racialized sentencing and racialized charging in our criminal legal system. There had been a really tragic Supreme Court case that had said that if you could show that the criminal law affected people disproportionately because of their race, that was not enough to deem it unconstitutional. And in the face of that, California lawmakers stood up and said, yeah, no, not in our state. In our state, if you can show that there's a disparate impact based on race with your sentence or with your criminal charge, that was not going to be acceptable anymore. And it's in the wake of that DA offices across the state started creating policies to say, oh, wow, if we have had a history of racial bias in our sentencing and our charging in our county, that's not going to fly anymore. And if we want to actually be able to do our jobs and not have those convictions overturned, we're going to have clear criteria that's not race, that's actually legal criteria. We're going to have to document it. We're going to have oversight to make sure that we can prove to the court that we really are doing this new thing. We're not just hiding the same old racial bull that was going on before. Um, and that kind of protocol now has to be in place. Um, and that's the background with which I think you and I were aware when you came into leadership that we had a real problem in our county. We had a long history of documented history, not by the DA's office, but outside the DA's office, of racial bias in charging and sentencing. And we had to have some kind of systematic way to show we were functioning with integrity. And that
All
was
right.
the birth of the special directive.
So let me take you back. You walked in the door with me in January of 2023. How did it feel to walk into the DA's office? What was it like in those early days?
You know, it felt historic. It felt like we were doing something that no one had dared to do before.
Mhm.
I remember, coming to the front door of the main office and people kind of looking, peering around corners and wondering, who are these people who are coming in, almost as if we might have three heads or something. And really what was historic about it is that we were bridge building, right? We were sort of like building connections with people who historically, if we had played by the rules that had always been, would never have taken place. So it was really historic.
Once I gave you this assignment, we're in this historic moment. We know that the office is vulnerable and has documented history of racial disparities in charging, sentencing, penalties. Did you find any kind of documentation being maintained by the office or any kind of consistent record keeping that would help us establish the absence of racial bias in prosecutions?
one of the biggest problems, which was reported on repeatedly during your administration, was the complete lack of data management in the office. So, no, we couldn't find internal data because there was never data managed, which put the office in a very vulnerable situation. Um, and I think you also had been very public about my assessment at one point that it was almost like we were in a 100-year-old startup. Um,
Right.
that that when you're in a 100-year-old institution, you expect there's going to be certain systems in place. And in fact, we found very little systems and many broken systems, with people leaving rapidly and not, setting up systems to maintain any semblance of organization. But around data management, there was a complete lack of data. So this is something that was frustrating, certainly for the media, but which you reported regularly is we couldn't compare, apples and apples over time because there was no comparison to make when they had not been maintaining data, let alone data disaggregated by race. So there were not those systems in place. And without having those systems, any office without systems that had a history of racial bias would not be able to defend its convictions unless it created some kind of credible mechanism for saying it was using different criteria than it used in the past.
So I recall that we convened a meeting of the deputies, and I know you were commissioned to go and talk to the charging deputies to find out what were they doing. What did you learn about what the office practices were before we got there?
Well, what was interesting to me is that I never really got any sense of a clear systematic process. And again, there was just like an absence of systems, which went along with, the absence of data management. Perhaps there really was no mechanism. If you're not maintaining data, there's two things that are happening. One is either you could have complete disorganization, where people are just making decisions for any old reason and then nothing's documented, or you could possibly have a real process. Um, that's not one that people want anyone to know about. I don't know
Right.
which one it is. We do know one of the things that, you were very public about is exposing that there was blatant racial-based rigging of juries on the part of members of the district attorney's office of specifically keeping Black women off of juries. As I told you personally, like it was as if you should have never been a juror, let alone a DA. Um, and we know that, and you disclosed to the court as you had to, as was the obligation, a constitutional obligation, that there was documentation of really inappropriate behavior in that kind of a decision around what jurors you pick or not. We certainly, if we had found something like that when charging, we would have had to disclose that too. So there was no kind of disclosure like that. But it begged to this bigger, broader question of like, what was the reasons that they were making the decisions? And some, I do want to say what some of the data was that we found from outside the office. So this is public data because I think it really raises this question of was this accidental or was it not accidental, which, I don't know. But this is the stuff a court would have to look at. So for example, um, the number of children, and since we're talking about violence against children also in this month of April, the number of children that were being criminally charged in Alameda County significantly decreased from 2007 to 2021. So the number of children pulled into the criminal justice system was going down significantly. But at the same time, the number of children being arrested and then charged as adults that were Black was going up. So the racial disparity was increasing. So in 2007, for every one white child who was arrested, there were four Black children arrested. But when you go to 2021, there were, for that one white child arrested, there was over 18 black children
Wow.
arrested, right? And that was public data available through Open Justice, and through the Department of Justice. That's public data. So this is what we were looking at, for example, of outside data. And that would create a presumption that there's something amiss, right? There's something amiss creating that kind of thing. And so, in the absence of hearing about what their actual real decisions were about, we knew the only option any DA's office would have in the face of that is to create really clear criteria and to say, okay, we don't know what you're doing, but moving forward, we are going to have legal, sound rationale for decisions around sentencing, which includes those conduct enhancements that we started the conversation with.
Right. And one of the things that we relied heavily on was the committee on the revision of the penal code. And you, particularly on page 5 of the special directive, which I think people should know, you had laid out what the direction was from the committee. So, can you talk a little bit about the committee on the revision of the penal code and how you relied upon it?
Sure. The Commission on the revision of the penal code was a broad commission created by the California legislature of specialists in criminal justice, in victims' rights, in reduction, in violence interruption. All were brought together to say, hey, how might we have to change our criminal laws, which is the penal code? How should we change it so that we really start getting to the root of violent conduct, and so that we also can build confidence in the rule of law among communities that feel like the legal system isn't fair? Because if you want to have a rule of law system, people have to believe in that system or they're going to act outside of it, right? So there were sort of two things. How can we reduce violence? How can we build confidence in the whole system? And this committee came together and created a number of recommendations. And one of the recommendations that they put forward was a significant control of the use of those sentence enhancements. So it was not a recommendation to eliminate them outright. It was a recommendation that they shouldn't be used, for example, if their use is racialized, right? So if there's a disparate impact, if a DA's office is realizing that they have a pattern of misconduct in using a sentence enhancement, maybe it shouldn't be doing that anymore, right? Um, if the person's crime was rooted in mental health disorder, there should be a therapeutic intervention that could help curb that violence rather than a punitive, just pure punishment, imprisonment response. If the person's criminal conduct was rooted in childhood trauma, and so I know, like, with April being talking about child abuse, if you have very injured children um who are never given access to care and treatment, you can imagine that their trauma can result in some inappropriate behavior in the future. It might not. It very likely
Mhm.
won't, but in some cases it does, and it can be directly tied to it. If that's the case, we owe as a society that person a level of care and attention, right? And also to help nip that in the bud and stop that kind of criminal behavior from ever happening again. So anyway, these are the kinds of things that the committee looked at and outlined and came to consensus on. And again, this was a wide swath of people, different politics background, different emphasis, again, with this dual goal of reducing violence as well as building confidence in the legal system. And so I really, for me, I took that to heart that, when I'm looking around, I was sort of charged with looking around and finding best practices. Like, how do we approach this topic in the best way? So I was like, well, here, this is where the best minds were brought together. Let's look at this for guidance. And what's interesting is that around the same time in 2021, um, Senator Skinner, who was a senator from our area where Alameda County is at that time, she came up with a bill, Senate Bill 81, that
Okay.
ended up being passed and it became law with Penal Code Section, I believe, 1385.
Right.
And it it put into law those recommendations from this commission.
Right. SB 81 came from
The
the
81.
commission.
commission. Right.
Right. It
Exactly.
Exactly.
came
Yeah.
Yes.
from that commission. And
Hmm.
it basically was advice to judges. It said, judges, don't use all these enhancements anymore unless you're in compliance with this.
Well, HB 81 is entitled Dismissal of Enhancements, right?
Exactly. Yeah.
Hmm.
So dismiss it because it's not in the interest of justice. If, you have these factors that the Commission on the Penal Code had thought were important factors, and it became law for judges. So if it's the law for judges and prosecutors have an obligation, an ethical obligation to uphold the law, and this is the law, then it made sense to look to that law to guide our written policies because it
Exactly.
was
Exactly.
already the law that was governing the office. It's already there.
Is there anything else in SB 81 that influenced the development of the policy directive on charging and sentencing?
One of the important elements of SB 81 is the way that it directed judges not to allow stacked enhancements. And what that means is charging people with absolutely every enhancement they could possibly face, like just piling it up, right? And that kind of stacking charges is something that has been recognized in the legal community and the constitutional law as unethical for prosecutors since the early 1900s, like before the Industrial Revolution. And the reason was because you can imagine if someone is facing 200, 300 years of prison time, if they really didn't even do anything wrong, they might agree to plea bargain and do 10 years in prison just because they are facing their entire life behind bars. Uh, versus if they were charged ethically in a way for what was really proportionate to what they're facing, they might only be facing 10 years and they might say, okay, you know what? I didn't do this. I'm going to actually exercise my constitutional rights and have due process. So that stacking is something, SB 81 mentions it. It was also just something that I think should guide all ethical prosecution. We should not be stacking enhancements.
Right.
Um,
And as I recall looking at the charging documents in our county, that was the routine practice. There were always 4 or 5 enhancements on every if there was a serious felony where an enhancement was charged, it wasn't just one enhancement, it was always multiple enhancements that were in fact on the charging documents that we actually inherited.
and
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 I think
so
so,
that as a general practice, that should cause the public a real pause. Because anyone then, right? When someone's facing charges, you're presumed to be innocent. That means that anyone could be fighting for their life, uh, over something where no one ever thinks a court will ever even approve that kind of a sentence. And that's really inappropriate.
one of
So
the
that was one
things,
thing that I feel really strongly about that no GA's office should do.
one of the things that we also found was that there were often the use of basically old cases to support enhancements or strikes. Can you talk about that?
Yeah, so SB 81 advised courts to th also dismiss enhancements if they were based on prior conduct that was over 5 years old. And case law, and also, again, that Committee on the Revision of the Penal Code also recommended throwing out old enhancements based on old conduct. So the idea is if, when you were a teenager, say you're 19 years old and you make a mistake in your life and you do something, later on when you're 60 years old, if you were picked up for something, you shouldn't look back at what you did when you were 19 because the reality is you've had many decades with no problem. Like it's not showing a pattern of behavior. And I want to say, like, the stacking issue or charging multiple enhancements, as well as this of looking at old deeds, to justify an enhancement, all of that is a presumption which could be overcome if there is evidence of an extremely vulnerable victim, an especially heinous crime, all of this was not, the way that the special directive was designed was not to be a blanket rule. Everything was supposed to be evaluated on a case by case basis because the law says everything should be done that way. And the whole purpose was to create confidence in the rule of law and the administration of justice in this county so that no one was treated differently. Everyone was treated in the way that the law is designed to be used. And that
So,
was really paramount.
based on your experience, how frequently did we actually approve enhancements, or did you see or learn of them being approved?
I mean, I was not the one making those decisions, but it seemed regular. It seemed regularly that it was happening.
In the spring of 2024, as I recall, we modified the special directive in a very significant way. Can you talk about that?
Sure. The way that you ran the office also provided for feedback loops and for us to be able to modify practice based on what the, union feedback that the union members provided in terms of how they needed to do their work. And one of the really cogent arguments that was made and which you responded to was to be able to, that there was a need to be able to charge people with an initial gun enhancement if a gun was involved in a crime, because that would also affect how bail hearings were made and a variety of other things. And so that was in fact done. So in initial charging, folks didn't have to ask for initial approval for that. They could just go ahead and do those charges. And that was a case of both being, flexible in terms of how the workflow needed to work in order to be functional, as well as also responding to the learned experience of people who had been doing that job for a long period of time and what tools they needed.
All right. So thank you so much for coming to talk to us on Pamela Price Unfiltered. And we appreciate your time and wish you well. Let's move on to legally speaking. Special Directive 2301 caused so much controversy in Alameda County. The legal basis for Special Directive 2301, however, was the report of the California Committee on the Revision of the Penal Code. Convened in 2017, the committee, established by the state legislature, spent 3 years interviewing 56 expert witnesses, holding public hearings, talking to victims and law enforcement officials and advocates and stakeholders across the state about the criminal justice system and the way the penal code works in our criminal justice system. There are hundreds of enhancements in the penal code, just so we're clear. After doing the work that they were commissioned to do by the state legislature, the committee made 10 recommendations for lawyers and judges operating in the criminal justice system. 3 of them specifically focused on enhancements. Number 5, provide guidance for judges considering sentence enhancements. Number 6, limit gang enhancements to the most dangerous offenses. And number 7, retroactively apply sentence enhancements previously repealed by the legislature. Those were the recommendations that were so relevant when we were looking at charging and sentencing in Alameda County. And here's the evidence that they relied upon. Number 1, California has the lowest crime rates recorded since comprehensive crime statistics began being recorded in 1968. Number 2, Nancy O'Malley, our former district attorney, speaking then as the president of the California District Attorneys Association, encouraged expanded programs for alternatives to incarceration, including programs for repeat offenders. Number 3, Santa Clara District Attorney Jeff Rosen suggested that all prison sentences should be cut by 20% across the board. Number 4, and this is the doozy, former Governor Jerry Brown offered that all sentence enhancements should be eliminated and more people should be granted parole. Number 5, Superior Court Judge Richard Cousins told the committee it would be fundamentally fair to allow any person incarcerated for more than 15 years to have a second look reevaluation of his or her sentence. Number 6, San Mateo County District Attorney Stephen Wagstaff, also a former president of the California District Attorneys Association, agreed that many criminal laws in California have lacked consistency and have no public safety justification. Finally, number 7, Governor Gavin Newsom acknowledged the jaw-dropping racial disparities in sentencing across the state and encouraged the committee to address the deep racial overlays and the deep socioeconomic overlays that often determine the fate of so many in our system. Another law that directly influenced the development of Special Directive 2301 and why it was so important and necessary for us to create a policy on enhancements and sentencing was the Racial Justice Act. It was passed in 2020 and became effective January 1st, 2021. Then also the Racial Justice for All Act, which amended the Racial Justice Act, was passed in 2022 and became effective on January 1, 2023, the first day of my administration, making the Racial Justice Act retroactive to cover past convictions and sentences. The act requires that if a conviction is tainted by racial discrimination or racial bias, the conviction should be vacated. If a sentence is tainted by racial discrimination or racial bias, the sentence should be vacated. So that's 2 back-to-back laws that were in effect when I came into office that were intended to root out racial disparities. Who is supposed to enforce the laws in our criminal justice system? It's 2 primary actors, the judge and the district attorney. They are both constitutional officers with broad powers to interpret, apply, and enforce the law. They operate together, but have different roles and act at different parts of the process. The DA is at the beginning, the judge is at the end. One major complaint of advocates across the state about the implementation of the Racial Justice Act since it was passed in 2020 and became effective in 2021 is that judges are not doing their job. But in Alameda County, your district attorney was doing hers. She's too soft on crime. No, she's actually smarter on crime than you think she is, and she cares more about what happens to people than you think she should. The presumption from day one was that we didn't know what we were doing. When the sore losers started squealing and complaining about every little thing, too many people were ready to accept the narrative that we did not know anything about how to practice law. In fact, because we live in a racist society, the media was easily weaponized to take down a powerful Black woman. We know the media thrives on anti-Black propaganda. The lie that is being told that enhancements were rarely used during my administration is exactly that, an absolute absurd lie. In fact, conduct enhancements were routinely approved, regularly approved in my administration, especially in sexual assault cases, child abuse cases, domestic violence cases, and homicide cases. Some idiot with half a brain made up that lie to sell news stories to the public. The Special Directive on Charging and Sentencing was never intended or designed or used as a blanket ban on enhancements. The exceptions are numerous and in black and white in the policy. It's also important to note that enhancements only apply to serious felonies. The overwhelming majority of cases filed by the district attorney's office in any county, and certainly in our county, are misdemeanors, and enhancements don't apply to misdemeanors. Let's take a look at the numbers. This is the breakdown of the types of cases filed by the Alameda County District Attorney's Office from 2017 to 2023. 2021, 4,980 felony cases compared to 9,435 misdemeanors. 2022, 4,566 felony cases compared to 9,800 misdemeanors. 2023, under my administration, 3,660 felony cases filed compared to 8,100 misdemeanor cases. In 2023, it was only 31% of that were felonies. In 2022, it was 32%. So, as a normal matter, only 1/3 of the cases filed by the DA's office are felonies and therefore subject potentially to some type of enhancement. By the way, this data was published on the data dashboard, on the public dashboard, on the DA's website under resources that my administration worked more than a year to create. It went live in January of 2025, in case you missed it. Only a few DA's offices in the entire state of California have a public dashboard. So let's talk about being smart on crime and why having a policy on charging and sentencing helps protect public safety. When I took office in January of 2023, the Racial Justice Act was just really coming of age. RJA motions were being filed and becoming commonplace and challenging filings, arrests, and prosecutions based on race. We knew that Alameda County was particularly vulnerable given the numerous published reports on the racial disparities and blatant racism by law enforcement in the city of Oakland, our largest jurisdiction, and others, and in the sentencing outcomes of our county. Does anyone remember the Stanford study on Oakland police practices? I do. I remember a lot of shocking statistics from the Stanford study. Like in 2014, Black residents were 4 times more likely to be stopped than whites. And when a traffic stop resulted in an arrest, 3,040 Black people were arrested compared to only 278 white people. The numbers of Black and Hispanic people incarcerated in Santa Rita County Jail is consistently 75% or higher of the total jail population. Black women across the state are imprisoned at 5 times the rate of white women. And we have no reason to believe that Alameda County does not also participate and contribute to that huge disparity. In 2022, a UCLA study on sentencing across the state, but for Alameda County, found that almost 71% of the people from our county serving life without the possibility of parole, or LWOP sentences, were Black. Almost 71%, while Black people make up less than 10% of this county. By comparison, less than 8% of the people from Alameda County serving life without the possibility of parole are white, while whites make up at least 40% of our population. Our LWOP numbers are twice the amount of the racial disparity across the state. In the state of California, it's 34% racial disparities. Our number is 71. Without a policy in place, any serious felony conviction can be challenged, and an enhancement is vulnerable and can be overturned under the Racial Justice Act. The Act requires that if a conviction is tainted by racial discrimination or racial bias, that conviction must be overturned. If a sentence is tainted with racial discrimination or with racial bias. That sentence must be overturned. Look around you. In April of 2023 in Contra Costa County, 4 men charged with murder and gang enhancements challenged their charges under the Racial Justice Act. The motion appeared to be substantial to us, and our instincts, our assessment of the motion was correct. In February of 2024, a judge ruled that the police racial bias had so tainted the investigation that under the Racial Justice Act, the gang enhancements against these 4 men accused of murder had to be dropped. So that's the impact of not having a policy. Over time, our policy, after it went in effect, we were able to create an infrastructure and a tracking system to support and protect fair prosecutions. Let me say that again, to support and protect fair prosecutions. Without a policy, you don't have that protection. And so when all of those protections were removed on day one of the new DA's administration, it opened the door to convictions for violent crimes being overturned in this county. It doesn't matter if you're dangerous or guilty. If you can show that any part of your arrest or prosecution was tainted with racial bias, you may get a get out of jail free card. Given our history, it should also raise serious concerns about the abuse of prosecutorial discretion. So what was our approach? We conducted a survey of all of the employees. We met with the charging deputies to find out what they were doing, what they were using, how they were trained. Were they being consistent with each other? We reviewed reports from the Council on Criminal Justice on charging and sentencing that came out in early 2023. We reviewed the recommendations from the California Committee on the Revision of the Penal Code. We relied upon SB 81, which was authored and led by our very own Senator Nancy Skinner from Alameda County as our guide. So we were following the law. In addition to making sure we were rooting out racial discrimination in charging and sentencing, we considered additional factors in making a decision to put the policy, Special Directive 2301, in place. One, the cost of incarceration. The California Legislative Analyst's Office estimates that it costs us $133,000 per year per person to incarcerate someone. Two, the Resentencing Act, which required us under California law to look at the sentences of thousands of people serving sentences from Alameda County that do not comply with the current law. And three, data that shows that longer sentences do not protect public safety and, in fact, make it more difficult for people to be successful in re-entering society. Nationally, politics, every day we see politics trumping common sense and fairness. So we should not be surprised to see politics trumping public safety here in Alameda County.